to this context of policing and controlling public assemblies. We hope that this webinar will help develop a community of practice that is aware of what constitutes torture in this context, that is aware of the tools that may be used by security forces and law enforcement, and the importance of centering survivors in accountability initiatives and the available avenues to seek justice for this type of torture. So, for context, the United Against Torture Consortium, as we call it, the UATC, brings together 6 of the world's leading international anti-torture organizations with the aim to strengthen and expand the anti-torture movement. We pool our expertise in torture prevention, survivor rehabilitation, and strategic litigation against torture. And the UATC harness the strengths of Redress, who I'm representing today, the Association for the Prevention of Torture, the International Rehabilitation Council for Torture Victims, the International Federation of Action by Christians for the Abolition of Torture, FIACAT, the Omega Research Foundation, and the World Organization Against Torture. The UATC responds to the continuous use of torture and other treatment in the context of growing threats to civil society, working on torture and on this increasingly volatile global environment that questions the eradication of torture and the global commitment that states have made to ban and to prohibit this practice. A key priority of the consortium is to address the torture that happens during or in the context of protests. At times, this is described as police brutality or excessive use of force, but this violence can often amount to torture or ill treatment under international law. And we find it important to characterize this violence as such where it does meet the definition of torture under international law. We have seen excessive force being used by military, police, or other security forces and law enforcement against protesters, either to intimidate, to silence dissent, or to discriminate groups. And this happens in many different contexts. We have seen violent crackdown of protesters in Peru, in Thailand, in Georgia, Kenya, Iran, and several other countries in the past years and decades. And we advocate for the use of the international anti-torture framework to prevent and to address this violence. And we believe that this framework provides a robust set of laws, rules, and standards that establish what force can and cannot be used in this context, what kind of tools should be completely banned from policing protest activities, or how some of these tools could be used in this context. And it also establishes the obligations of states to prevent and to address torture. So we have seen that these obligations have been upheld by different international human rights courts. The Inter-American Court of Human Rights, for example, has repetitively discouraged the deployment of the military for policing assemblies, given that military personnel is trained to fight an enemy and not to protect civilians. The European Court of Human Rights has also established that force can only be used exceptionally in protests in a legitimate, necessary, and proportionate manner. The African Commission on Human People's Rights has condemned sexual and gender-based violence against women protesters, and the ECOWAS Court has recognized that survivors are entitled to reparation, including compensation for the harm they suffered in protests. So these obligations are well established, and I would like to take the opportunity to mention that last year the UATC, the consortium, has published 2 policy papers on torture in the context of protests. We will share the links so they will be accessible in the chat. The first policy paper is titled Protesting Without Fear. It analyzes the international standards on the use of force that apply in the context of protests. It examines how these violations can amount to torture in the international law. And it assesses how the intentional use of certain less lethal weapons to intimidate, punish, or discriminate protesters can cause injuries that violate the absolute prohibition of torture. The paper also provides a series of legally grounded and practically oriented recommendations to state actors based on the application of this international framework. The second policy paper is called Challenging Repression. This is a guide to addressing the misuse of police weapons in protests. This provides a practical tool for civil society monitors working to safeguard the right to peaceful assembly. It gives them accessible overview of the law enforcement weapons most frequently used against protesters, the risks that they pose, and the patterns of misuse. So we encourage you to access those resources in your own time. Turning now to today's webinar, on our panel today, we are honored to have the voices of survivors and lawyers with experience in advocating for accountability in cases of torture in protests in Nigeria and in Thailand. We have also experts in the tools and equipment used in torture in protests and in the applicable international law and standards. Again, if you have questions, please post them in the chat and we'll collate them and address them later. First, I would like to introduce our panel of experts. We have today with us Ogoke Ngozi Gladys, a survivor advisory board member of the International Rehabilitation Council for Torture Victims, IRCT. Ngozi is a Nigerian survivor who's passionate about empowering fellow survivors and advocating for their well-being. She brings a profound understanding of the challenges faced by victims of torture. She survived and recovered from severe physical and psychological torture. She majored in English studies and worked in human resources, which helped her build excellent communication and interpersonal skills. That she has located fellows that were imprisoned with her, and she has referred them to the Nigerian Rehabilitation Center called Prava. And in some cases, the survivors' contact with Prava was actually their first contact with a human rights organization that could provide some sort of support. And so Ngozi, support of fellow survivors has been absolutely essential in their path to rehabilitation and reintegration to that communities. Thank you, Ngozi, for joining us. We also have today with us Helen Close, senior researcher at the Omega Research Foundation. Helen, she works on issues surrounding the use and the trade of law enforcement weapons and equipment, pushing for greater regulation of weapons used in the policing of protests, as well as for accountability when equipment has been misused. She also runs workshops for human rights defenders and civil society organizations around the world on how to monitor protests, focusing on identifying this equipment that is used and documenting police use of force. Her recent work in this area has included collaborating with other members of the United Against Torture Consortium that I mentioned to identify equipment used in countries such as Georgia, Iran, and Kenya. Thank you, Helen, as well, for joining us. And we also are joined by a colleague from Thailand, Pompen Kongkachonki, former director from Cross Cultural Foundation, which is an organization that monitors and documents cases of torture and ill treatment in Thailand. She has been involved in various human rights issues, both in Thailand and in the region, including women's rights, indigenous rights, and preventing forced disappearances. Her work serves the public interest by ensuring that authorities are held accountable and pressuring authorities to unconditionally respect the human rights of all. She represents survivors and victims of torture, including those who suffered abuse in protest, and will be sharing some of her experience in pursuing accountability for this form of torture. So thank you very much to all our speakers and again to our audience today. To start this panel discussion, I would like to ask a couple of questions to all of the three panelists, and I will start now with Ngozi. Ngozi, the first question that we have for you is, how can survivors' voices and experiences help expose perpetrators, and what is the role of survivors in seeking accountability for what they suffered?
Thank you very much, Renata, for having me. On behalf of survivors from Sub-Saharan Africa countries, survivor advisory board members at the IRCT, and survivors all over the world, once again, I want to say a very big thank you to Redress and the UATC for bringing this webinar together and considering survivor voices in this very important discussion. Once again, my name is Ngozi Ogoke, torture survivor from Nigeria. I function at the Survivor Advisory Board of the IRCT. How can survivor voices and experiences help expose perpetrators and advance accountability. Well, needless to say, survivor voices and lived experiences are the foundation of trauma-informed, survivor-led justice, healing, and accountability. Survivors possess first-hand knowledge of torture practices. They possess first-hand knowledge of perpetrators, systemic failures, making their testimonies a powerful tool for exposing abuses and challenging impunity. Therefore, talking about torture in the context of protests, we have to first admit that freedom of expression, association, and peaceful assembly are fundamental rights guaranteed under national constitutions, regional laws, international instruments such as ICCPR and UNCAT. If we have this in consideration, then survivors of torture must exercise these rights to demand justice and state accountability. My experience as a torture victim illustrates this power vividly. As a survivor of torture during the popular EndSARS protest in Nigeria that shook the foundations of this country, after my experience, I stood against my illegal arrest, incommunicado detention, and severe physical and psychological torture. My struggle not only registered my rights of self-determination, but it also enabled me to fight for justice. I was ultimately given relief when the Federal High Court in Nigeria here declared my torture illegal, my detention without access to lawyers illegal, and my physical and psychological torture illegal. When I got that judgment, it brought some level of satisfaction to me. While standing against the odds and speaking for my agency, I transformed my personal suffering into public accountability. Yes, I did, because I took my matter to the courts. My case demonstrates how survivor testimonies can expose perpetrators, it can mobilize legal action, deter future abuses by signaling that torture leads to set legal consequences. So in this context, looking at all these narrations, you can see that there is no way a survivor who has gone through trauma, who has gone through torture, comes up with the story, tells her story, brings her voices to the public without, leading to accountability, leading to exposure of perpetrators. Thank you.
Thank you so much, Ngozi, for sharing a little bit of your story and your path to this. And you've been such an inspiring force to so many of us within the consortium and beyond. And so I just wanted to pick up on one point that you mentioned and to say that, it's so important that survivors have their agency recognized and their role in this avenues to accountability and processes of accountability. And there are different ways of doing it. But I wanted to ask you, what kind of recommendations do you have for civil society organizations, lawyers, and other practitioners that are accompanying survivors in these processes to justice? What is the best way to support survivors in these processes, especially as we know that some of these processes towards justice can be very long, cause a lot of fatigue, and they pose many challenges. But it's important that we are aware of what kind of tools we have to provide the support and how can we be most useful to survivors in this journey. So if it would be great if you could share a bit of your experience on that.
Okay, thank you very much, Renata, once more. We all need to know that justice for torture survivors is not an easy walk. Survivors, justice for torture survivors requires sustained, coordinated and survivor-centered efforts. It is not a quick fix. Based on my struggle and lived experiences, I would like to share my key recommendations to CSOs, legal practitioners, and every other human rights activist. First, from my experience, I will advise that there should be a proactive legal intervention. Because while I was in the detention, I saw firsthand how torture victims died in detention places. And then I imagined if there was a legal intervention at the right time, probably those people would have rescued before they got into that state. And then not just those that died in detention, there are some survivors that also, after their release, they find it difficult to even get legal, pay for their legal whatever at the courts. So they die with such experiences. Nobody came to their. So I'm advising that legal practitioners should please visit detention facilities, listen to victims of torture, hear what their problems are, know where to attend to them. Those that needs to be taken to the court, they should rescue such people very much on time. Then that is talking about proactive legal intervention. Then again, talking about comprehensive rehabilitation support, CSOs, human rights defenders, survivors networks should provide integrated psychological rehabilitation, medical care, livelihood support for holistic well-being of these survivors. My recovery was supported through rehabilitation and livelihood assistance by PRAWA, Prisons Rehabilitations and Welfare Action in Nigeria, courtesy of IRCT networks, demonstrating the importance of coordinated survivor support system. Thirdly, survivor network and peer support. I would advise or appeal to CSOs to please strengthen and provide peer support to encourage disclosure and amplify survivor voices. Such networks empower survivors to speak out collectively and reduce stigma and isolation. There is also still systematic accountability and policy reform, which I will also advise that practitioners should advocate for implementation of court judgments and reparations. Look at my case. I got judgments in 2023, and up till date, it has not been implemented. I am still hopeful. So how do I get my judgment implemented? That is where I bring in these practitioners. Please ensure that when we get judgments, that it is implemented. I do not know how they go about it, but it's I would not say it is a waste to get judgment in. No, it isn't a waste. It is very good that I got judgment in the first place, but I also would wish that my judgment is implemented, because at the judiciary, they were at the courts, at my judgment, they were asked to make a public apology to me and pay some compensation. All those I never got. So I would also appeal to practitioners to please pay attention to systematic accountability and policy reform, independent monitoring mechanisms on complaints and NPMs. I mean, optional protocol to the Convention Against Torture. All those are instruments that can be used. National preventive mechanisms, they are instruments that can be used to ensure that there is accountability when we are talking about policy reforms. Survivor participation in policy monitoring. Yes, like I continue to say, survivor voices are very, very important in the place of anti-torture movements. Whatever we do about policy change, monitoring at the detention facilities, I keep encouraging that survivors should be brought in, let them participate, because they have first-hand information of what happens in these detention facilities. They have first-hand information of the systematic failures. We can help a whole long way to support whatever you do in the area of participation, survivor participation in policy and monitoring. So these are the areas I will actually advise that CSOs, lawyers, and practitioners to do their best to support survivors who are seeking justice. Thank you, Renata.
Thank you, Ngozi. Thank you so much for this and for reminding us of all these important recommendations and the importance of holistic support to survivors and the challenges and the need to continue to advocate for the actual implementation, making sure that reparations are realized in practice as well. So with that note, I'll just remind our audience, if you'd like to post some questions in the Q&A chat box, please do so, and we'll get back to Ngozi in a moment and in our Q&A. I would just like to move to Helen now, our expert from the Omega Research Foundation. It's often difficult to understand some of the international standards on policing of protests. We know that law enforcement has some role in protecting the protesters and demonstrators during these assemblies. But can you explain to us what is exactly their role when they are policing, and what force and tools are they allowed to use in this context?
Thank you, Renata, for the introduction, and also for inviting me to speak on this important topic. And also thank you, Ngozi, for your testimony and reflections. It's so important to have the role of torture survivors in this conversation. So when it comes to law enforcement and their role in policing peaceful protests, the police aren't there to suppress the right to protest, but to facilitate it while maintaining public safety. So they also have a role in maintaining the safety of protesters, counter-protesters, the general public, as well as the bystanders. And police have a positive obligation to ensure that people can protest safely, even when the protests are critical of government policy, or if the protest is unauthorized. There are international standards that lay this out. So they include the UN Basic Principles on the use of force and firearms, as well as things like the UN Human Rights Guidance on less lethal weapons. And these documents outline principles that govern the policing of protests, two of the key ones being necessity and proportionality. So the principle of necessity says that force can only be used when it really is strictly necessary to achieve a lawful and legitimate objective, and there can be no reasonable alternative available other than the use of force. When force is used, it must be the minimum force required and end as soon as the need passes. And then we have the principle of proportionality, which states that the level and type of force used must be proportionate to the threat posed and the legitimate aim pursued, balancing the expected harm caused by the benefit, the legitimate benefit to be achieved. It's also really important to remember that if some protesters engage in violence, police should not treat the entire protest as violent, but manage the violent individuals. And protesters engaged in violence may forfeit their right to peaceful protest, but they retain the right to life and freedom from torture. So turning to the police use of force in protests, and particularly the use of equipment, police do have a range of force options available to them when policing protests. And this is often described as the use of force continuum. It ranges from minimum intervention, so that's protecting bystanders, perhaps cordoning off particular areas of concern, to verbal commands, so that's negotiation and de-escalation techniques, to more coercive measures, so that might be containment, physical restraint, and then also the use of less lethal weapons. There are different less lethal weapons available. These can be equipment such as batons. They can be chemical irritants, so such as tear gas and pepper spray, so small handheld sprayers. They can also be hand thrown or launched ammunition that contain tear gas and chemical irritants. And then also kinetic impact projectiles, colloquially known as rubber bullets. There's also water cannon that spray water at high pressure, and this can sometimes be mixed with tear gas or dye. It's mixed with dye to enable police to identify protesters afterwards. And then there's also things like stun grenades. You can find more information on kind of weapons types on the Omega website, which I hope is going to be put into the chat. There's too many types of equipment for me to go into them here. But there should be procedures in place to govern the deployment and use of each type of less lethal weapon. And then when it comes to firearms, law enforcement officers at a protest should not normally carry firearms. So firearms may only be used when strictly unavoidable to protect life and never, never, ever to disperse a protest. So just to summarise, law enforcement must facilitate protests. Force is always a last resort, and any force, including use of weapons, must comply with strict human rights standards. Thank you.
Thank you so much, Helen, for clarifying these standards to us. We know that this policing of assemblies, the monitoring and the protection of protesters is an obligation of the states, and it's very useful to understand what are exactly the principles and norms that they should follow in this context. I think I just wanted to ask you to develop a little bit more on the specific use of force that becomes unlawful. When does force become unlawful? Because we are aware of these principles. It is necessary, it should be proportionate, etc. But how can we identify when it's not proportionate anymore, or when it's not necessary? And if you could give us some examples on some of this equipment that they use, that you've seen most used in protests, such as those that you just mentioned now, that would be really helpful to give us some more clarity on those. Thank you.
Thanks, Renata. That's a really good question, and it is quite difficult to distinguish when force becomes unlawful. So it becomes unlawful when it violates the use of force principles. So that's necessity and proportionality, but there are also some others. So that's legality, precaution, and non-discrimination. So legality, the principle of legality states that force must be clearly regulated in domestic law, and this domestic law must be consistent with international human rights standards. And the laws and rules must be clear and accessible to the general public. There's also the principle of precaution. So law enforcement should plan an operation, so plan for policing a protest, and conduct themselves in a way that avoids or minimises the use of force, focusing on de-escalation techniques and providing advanced warnings if they are going to use force or deploy weapons. And then we have the principle of non-discrimination. And so people must not be targeted on discriminatory grounds like race, ethnicity, religion, gender identity, or political affiliation. Authorities must also recognise that force affects people differently and take extra care to protect those at greater risks, for example, people with reduced mobility or young people. It may also amount to torture when it intentionally inflicts severe physical or mental suffering for a purpose such as punishment, intimidation, coercion, or discrimination, or it might amount to other cruel, inhuman, or degrading treatment. So when it comes to weapons and equipment, use of force can be unlawful due to the actual design of the equipment. So if the equipment that the police select to use inflicts excessive force due to its inherent design, this could this type of equipment could be something like ammunition that contains multiple kinetic impact projectiles. So, for instance, if ammunition fires out several hardened rubber balls, as these are impossible to aim accurately, it makes them indiscriminate, and they can hit somebody with a lot of energy and cause significant injuries to vulnerable parts of the body, like the eye. We have been involved in a legal case on this, along with redress. In France in 2016, a man called Mr. Theron was attending a protest in France, and he was hit with a fragment of a less lethal grenade in the eye, and he was blinded. The grenade used explodes when detonated, releasing multiple projectiles. And the officer was charged but acquitted in the French courts. They found that the use of the grenade was proportionate. So they used the test of proportionality and necessity. The case then went to the European Court of Human Rights on appeal, and Omega and Redress have intervened in that case, stating that the grenades were indiscriminate and the risk of injury were severe. So saying that it doesn't meet those thresholds. This case is still pending, but I thought it's a useful example of the kinds of legal tests that can be applied to the use of the equipment. So as well as the actual design of the equipment, there's also the way equipment is used. So you have ammunition containing chemical irritants. So as I said, that ammunition containing chemical irritants can only be used or may only be used to disperse a crowd that's engaged in widespread violence that can't be contained through less targeted measures against violent individuals. It shouldn't be used to disperse a peaceful protest. So therefore, it can cross into ill treatment when it's indiscriminately used against largely peaceful crowds. It's used without warning when it was possible to give a safe warning. If it's used in situations where the protesters can't disperse, so perhaps their exits are blocked by police, or excessive quantities of tear gas are used, causing avoidable breathing difficulties. And then also if the ammunition is fired directly at people, as this can cause impact injuries that are foreseeable. And also if they continue firing after a crowd is dispersing. And then depending on the circumstances, the use of tear gas could sometimes meet the threshold for torture if there is an intent to punish protesters, intimidate population, coerce individuals, or discriminate against a group. So across all these tools, key themes emerge that indiscriminate use is unlawful, punitive use is unlawful, and excessive use is unlawful. And where severe pain or suffering is intentionally inflicted, accountability mechanisms related to torture really must be engaged. Thank you.
Thank you so much, Helen. It's very useful to hear those examples and to better understand the exact limitations on the use of this sort of weapons and equipment. And we'll come back to you, I'm sure, with follow-up questions. For now, before we go to our other speaker, Noi Noi, I'm just going to hand over to my colleague Andrew Lane so that we can have a very short activity, and we'll be back in like 5 minutes. But please stay tuned for this activity as it's also an opportunity for us to hear from the audience some of your experience on this.
Awesome. Thank you so much, Renata, and Helen and Ngozi, just for a really amazing first half of this webinar. Let me just share my screen. Hopefully everyone should be able to see that now. So for the next 5 minutes, we're going to do a short reflective activity. The purpose of it is to basically enable us all to learn from each other's experiences, and we're going to use a Mentimeter to do that. And this is also a break for our interpreters, so we won't have translation during that time. To join the Mentimeter, as it says on the screen, you can either click the link in the chat, or you can scan the QR code, which is now on the screen, or you can go to the Mentimeter webpage, which is www.menti.com, and use the code, which is there, 85551770. And basically,
I don't think we can see the screen just yet. Sorry to interrupt you.
Oh, no, thank you so much. There we go. That should be there now. Can everyone see that?
Yes, perfect. Thank you.
Fantastic. So yes, if you join via one of those methods, the idea is that this is an interactive sort of small survey. You'll have 4 questions, and if you could just kind of give your responses, we'll go through the responses as a whole webinar session. I'll display the results for 30 seconds and then kind of keep revealing the results after 1 minute. You'll kind of understand it as we go through it. Try to keep sentences like sort of one sentence answers, fairly short responses. So let me go over it now. So this is our first question. In your experience, what are the main barriers in documenting police violence during protests? And I'll just bring that over now to the Mentimeter. Again, feel free to join via this QR code or via the website with that number below. Some really interesting responses there. I'm now just going to move on to the next question, which is, how can you support survivors as they seek justice and accountability for violence in protests? I'm now just going to move on to the results. Thank you so much, everyone, for your responses. Now just going to move on to our third question, which is, what are the best methods that you have found to seek accountability for survivors of torture? Thank you so much. These are really, really interesting. I'm just going to move on to our final question now, which is, how can the international community support advocacy efforts following torture in protests? I'm just going to move on to our final results. Fantastic. Thank you so much, everyone. That is the end of our short activity. So I'm going to hand back to the panelists and Renata for the second half of the webinar. Hopefully this gave the interpreters a brief rest as well, so they should be back online shortly. So yeah, Renata, I'll hand back over to you.
Thank you very much, Andrew, and thanks everyone for sharing your responses. It's really useful to know and learn from the experience that we have in our audience as well. Coming back to our panelists, I'm coming to you now, Noi. Thanks again for joining us. We also have a couple of questions, and the first question we have for you is, how have you sought accountability for protest-related torture in Thailand? And what can others who are challenging this practice in different parts of the world learn from this experience?
I thank you very much for including Thailand also in kind of lesson learned. I'm here from Thailand. I'm based in Bangkok, but I was asked to specifically talking about one incident of the protest in Thailand that we have used strategic litigation in order to hopefully prevent the violence happen to the protest and also reform over the practices of the law enforcement and security. I'm going as a human rights lawyer. I'm going to talk about one incident which called Tak Bai incident. Tak Bai incident actually happening in our Muslim minority regions in the southern Thailand. If you can imagine Thailand and at the south of Thailand, it's Malaysia. So Pattani is in between of Thailand and Malaysia, and there have been predominated Muslim region. Our country is Buddhist and also militarized during that time, and also in many years in Thailand, we also under military coup d'etat. So in that region, there is a case where martial law was declared in 2004, and 60,000 or more troops from the central Thailand, east part, west part, has come to sort of operating in the 2 million Muslim population. So during that time, there was a lot of security measure and also arbitrary detention, torture, allegation, extrajudicial killings. And in October 2004, which is 22 years ago, there was a protest against one of the arbitrary detention of a 4 village armed force. The villagers were arrested and detained, and public or villagers or community protest to release of those 4 individuals. And only in few hours, there was a lot of people getting together, and military officer, police officer, and the local administrative officer have decided to crack down on the protest with violence. Of course, it's always starting with announcement to disperse the protest, water cannon, tear gas, like our friend was saying about the tools that actually some of the tools are excessive and cause injuries. However, there was a time during around 3 o'clock before shooting happened. So at that time, the shooting has happened and 1,300 protesters were arrested, and they were asked to take off their shirt, to tie up behind with 2 arms at the back, and they were going down in front of the police stations. And that protest is end up that every single people of a villager who was arrested, around 1,300 people were transported from one location to another location overnight in the military truck, and they were piling up. So all of them were subject to ill treatment, and psychological torture, also physical torture. So 6 people died from the shooting at the incident, and another 78 people died from suffocation in another location. That incident happened on 25th of October 2004. So along the way, there was a number of fact-finding and investigations going on. However, there was not successful to persecute anyone during that time or along the way until very last year in 2024. We have a statute of limitation of our criminal code that the case had to be rendered to the court with the defendant in hand within 20 years before its statute of limitation is expired. So with an effort from local lawyer, Muslim Attorney Center, Lawyer Council of Thailand, CRCF, and also I would also saying about the victims or the survival family. We were encouraged by a number of public discussions during that time. Due to the campaign also on Anti-Torture and Enforced Disappearance Act, torture was not criminalized. Enforced disappearance was not criminalized during the time when by incident happened. But along the way, torture was experienced by a lot of Muslim population in that region. So we put together the effort to draft the law with the lawyer in Bangkok, in many other political parties was jointly supporting Anti-Torture Act. Anti-Torture Act was enforced 3 years ago. It was enforced during the time when we start doing the statistic litigation. But the law cannot be used because we cannot retroactive the law. But I would like to say that the sentiment, public acceptance that torture is bad and now illegal, is helping the strategic litigation to go ahead within 1 year. 12 months is not long for strategic litigation for 78 victims of death and also 1,300 torture victims. So we were able to put it together and charge military guys, general, police, and other administrative officers. And it's for the first time that Thai court have actually issued the arrest warrants against generals. So it's a lot of effort that has been done and a lot of challenges. So as of now, I just wanted to stop first because it's quite a long story, but strategic litigation that had happened is actually inspired a number of other individual cases and also other protest cases that they really wanted to pursue. But now the statute of limitation is expired. So it's just a lesson learned for us and then a lesson learned from law enforcement officer. Thank you.
Thank you so much, Noi, for sharing that experience, and it's an illustration of impunity that I think repeats in so many different places, and despite the international ban on like the statute of limitation for torture, there's continues to be a barrier for accountability in many different countries. But it was fascinating to hear about some of the impact that strategic litigation has achieved in the sense, and all the campaign along it, including the criminalization of torture and how it can help from now on, survivors in pursuing justice. I wanted to ask you if during this process and this long advocacy and litigation efforts, if you saw any sort of role of the international community in these accountability efforts, and to ensure that perpetrators of torture in protests do not remain unpunished. Was that useful in your experience or not? Or how did you take advantage of those specific international opportunities, if at all?
Yes, very much so, because during that time we had a lot of support from ICJ, Redress, ONCT, and also UN mechanism. The CAT review is very helpful also in order to bring up the issue like that to be highlighted in the recommendation to Thailand. And of course, there are some funding also supporting human rights lawyers from international community, from ONCT. During that time, we're going to review second time of the CAT review. And we also, not only international support, we have also get a support from Lawyers Council of Thailand. They also supporting financially for the lawyer to work with the survivor, because their victim families are getting very old, and also we have to interview again, or even we have a lot of documentation in the past. All the challenges, it has been overcome by an effort from the survivor community. And the survivor community itself, can you hear? Survivor community itself also have been supported by a small group. They are doing memorization. I think sometimes the torture and forced disappearance group or family or affecting community, they need some kind of relief project like art therapy, and also this a very powerful small group is doing memorization by taking the memorized items to show for Bangkok people or other part of the Thailand in university. So the story of Thak Bai is not just the story that happening in a small region of Thailand. It has been distributed publicly, and it's supporting the story of bringing perpetrator to justice, making an arrest warrant of the general, which is the very first time. If you know the history of Thailand, it has been difficult for the judge to stamp on the arrest warrant against general, because we have coup d'etat very often, and loyal family, and us also supporting the military operation. So it has been support from all over Thailand, and I think because of sentiment of the anti-torture law and enforced disappearance act, it's actually picking up the standard of public in general and the media in supporting this campaign at the national level of in Thailand. And the law is being applied for 3 years, and we can see that torture report allegation has been addressed in a different way before the law is enforced. So Thak Bai is contribute to the drafting of the law, and at the end, even it's not successful through being perpetrator to justice, but the story of Thak Bai is supporting the effective implementation of Anti-Torture Act. And one more thing, the act is also contain another offense, which is ill treatment. So Thak Bai incident can also be seen as an example of ill treatment, inhumane punishment, even the psychological torture. Even though we cannot get redress and a proper compensation, but everyone can see that it's already as a precedent that treating protests like that, putting them piling up in the truck, make them suffocate until die or injure, it's actually illegal now. Thank you.
Thank you so much, Noinoy, and I'm sure these examples and your experience will serve as, you know, an inspiration and as a great example of how to do this in different countries. So without further ado, I'm just going to pass on back to my colleague Andrew Lane, who will help us with the Q&A section. Thank you so much, everyone, for your questions. I will try to address as many questions as possible during this last half hour. Thank you.
Yes, thank you so much, Renata. We've got a really exciting Q&A coming up. There's lots of, I feel like there's so much to discuss, so I'm going to get straight to the questions. I think we got two questions in the chat, which are kind of directed towards Helen. I think, Helen, you might be able to give the best answer to this one. So the two are, one respondee said, protests in my country, Argentina, are met with violence. And I would like to know if there are any safeguards in place when it comes to indigenous communities. And then the second one is, torture weapons are systematically employed to crush protests in many parts of the world. And in the cases you've been involved with, have there been any lawsuits against weapons producers? So chime in with that, Helen. Probably you'll be able to give the best answer, but if any of the other panelists want to contribute, then feel free.
Thanks for that. Just on the last question, when it comes to legal cases against producers, we have looked into that, and there have been some cases. We've made efforts to take cases at the OECD level to stop the export of less lethal weapons. I think there was a case of South Korean companies exporting weapons, but it is very difficult. We found it very challenging to be able to do that. And we've also looked at pursuing firearms producers where their products have been used by law enforcement agencies and associated with human rights violations. But it is something we're looking to develop, but it is very difficult to produce, to pursue these legal cases. We've also looked at pursuing cases within like parliamentary and governmental systems within the UK, for instance. So looking at the actual export licenses to export equipment from the UK to another country, you need to get an export license. And if the equipment is being used, it can be shown to be used to be causing torture and ill treatment in the country that it's going to, you can get the license stopped, but you can't kind of get the weapons recalled. But we've looked at that with regards to UK equipment being exported to Hong Kong, for example. Yeah, and then the question about Argentina.
Yes.
The issue there is really looking at non-discrimination. So it's the use of force principle of non-discrimination. So that is the protection that does exist, as that use of force should not be used against a particular community and shouldn't discriminate against that population.
Thank you so much. That's so insightful. I suppose on that point of indigenous communities, if I could open it up to the wider panel, if anyone else has some comments on what safeguards can be put in place for indigenous communities in particular.
Thank you, Andrew. I might take that one. Then I think one aspect that we found important in litigating cases of torture, where there is an element of discrimination, is to understand the general context of that particular country. And so it's very important to demonstrate where there is a specific hostile environment, or where there are specific groups that are being targeted because of who they are or what they represent. And this is important when you're producing evidence for litigation, but also, as mentioned by Helen, on the enhanced obligations that states have in preventing this torture. So you often see in cases where there has been a discriminatory element in play that international courts, like the Inter-American Court of Human Rights, has recommended very specific measures to address the root causes of discrimination and to prevent those practices. So, for example, if we are speaking about indigenous communities or other socially excluded or marginalized groups, the Inter-American Court of Human Rights has understood that there are obligations on states to ensure that police officers or other law enforcement agencies are actually trained on the specific vulnerabilities or the specific use of force that they should use, and that enhanced prevention element that they need to employ in these circumstances. And so I think we can post in the chat. I think the case of women of Atenco in Mexico, ruled by the Inter-American Court of Human Rights, can be useful in that sense. But we can also post in the chat or send it later over email other examples as well. And I don't know if you were going to come in on this one as well. Sorry.
Yes, I just wanted to share some it's a safeguard, but it also has been difficult in Thailand. So many times the crackdown on the protest, if not like in the region with the martial law or any special measure, they will not crack down with the violence. So after the protest, a number of them would be charged of anything against the law in Thailand, like Public Assembly Act and also the Traffic Act or something like that. So one of the safeguards that it also happened to indigenous people from other parts of Thailand coming to protest in Bangkok is also to really gather together and also have your lawyer in hand in order to help documenting the protest to save you from being charged or legal harassment. So, for example, in Bangkok, we also have a team of lawyers prepare in order to help the indigenous people and also people from the other part of Thailand when they come to Bangkok. So we prepare beforehand what's going to happen, and we document the incidents in order to use it when we have to defend for them in the legal harassment that might happen to indigenous people group who coming to Bangkok for their protest and advocacy. That's maybe very simple safeguard, but it is really helpful.
So Ponpen, it's about the proactive legal approach, actually, which is something I think Ngozi alluded to before in the panel discussion. So it's really interesting to hear it coming together.
Yeah.
I have a sort of follow-up question for you, if I may, which is from the chat, which is how can survivors safely report torture without fear of retaliation?
For me to answer?
Yeah, or for anyone on the panel that feels able, or Renata, or yeah.
Yes, I think for us, when we are documenting torture, when we are trying to bring them back to their normal life in a very intensive situation as well, like in the southern Thailand, the martial law is applied throughout 20 years from the incident until the litigation has been successful. So to maintain the family of support, so the survivor needs the family support, and the family support needs paralegal, needs paramedic, and also community activities. So we have been trying a lot of yoga, Reiki, because all these torture survival in the context in Thailand, they are Muslim, and our medical facilities are also secured by security officer. So we have to find an alternative treatment, and sometimes we have foreign doctor, even from Switzerland, from from India, from Manipur, who are having the same context in order to come and share. So we expand our assistance to not only survival, but to the family, and also spread the story or documentation to public in general. So that's why we can campaign for the law, because the survivor were able to speak by themselves when the law is at the level of the parliament and things like that. So it's powerful when they been able to speak out in the parliament, when they're defending and storytelling to the media. So you have to be prepared also, survivor, to talk to the media when they can even talk to the family member community. They talk to the media. That means they are overcome and they really help the lawmaker and everyone understand the impact of culture. That's maybe what's the answer.
Thank you so much. Yeah.
Thank
Yeah.
you.
Would anyone else like to come in on that? Otherwise, I can move on to the next question, which also came from the chat, which is a question for Ngozi, actually, which is the participant says, I'm happy to hear that you got a judgment or reparation in your own country. How do you encourage other survivors who are tortured by their own government and have been denied justice? How do you encourage survivors to become an advocate and advocate for policy change in difficult circumstances? And I think that also goes with some of the sentiment from the Mentimeter activity that we did 20 minutes ago, where with the question of methods of accountability for survivors, some respondees express frustration, what avenues are there for accountability? So yeah, how in those difficult circumstances, how do you deal with that frustration and also encourage survivors to kind of advocate?
Okay, very good. Going by my own lived experiences, one thing I keep telling other survivors is, if you do not speak up, you do not get help. When I passed through this experience in my life, I came out and I was lucky to find out that some lawyers had already gone to the courts on my behalf. And I was so excited. So when I came out, before I even came out, I had been threatened by the security officers never to discuss what I passed through in their hands. But when I came out and I saw that some lawyers were already in court on my behalf, I joined them. I didn't keep hiding. I didn't allow fear to overwhelm me. I decided to join the legal team that were fighting for me already. So I encourage torture. When you come out, when you survive torture, try to speak up. And that is why in the earlier question I was asked about what I wanted CSOs to do for survivors to help them get justice and healing. I said, supporting peer network, survivor peer network is very, very important. Because if we have a peer network where survivors come together collectively to share their experiences, it helps them, especially those that haven't gotten justice yet. It will help them as other people share their experiences. Okay, look at it. For instance, I'm in a peer network platform, and I continue telling them what I have gotten so far by speaking up. I've gotten justice. I've gotten, I've somehow my psychological healing, knowing that my rights were, infringed on and all that, getting compensation, even though it hasn't been paid, and then asking the government, asking the state security to make an apology to me in the public. When I share the legal conclusion of my matter in a peer network platform, it will encourage those that haven't gotten justice yet to reach out, to speak up. If they do not know how to access lawyers, from my experience, I can teach them, I can help them know how to get reach practitioners could actually help them. So when you look at the judgments I got, it brought accountability. You know, perpetrators were officially identified. The court ruling asked them to apologize to me in public papers and pay compensation. That justice also brought about healing for me, because psychologically I was okay, good. My rights, it was my fundamental rights to even join in a protest. It wasn't a crime in the first place. So that judgment brought even about my dignity, you know, legal recognition restored my identity as a rights holder, not merely as a victim anymore. You understand? So judicial recognition is also very crucial for collective memory and systemic reform. It sets legal precedents and validates survivors' narratives in official records. So let survivors speak up. Let there be a platform to encourage them to speak up. If they do not speak up, legal practitioners will not reach them. So if we have a peer platform where CSOs can actually strengthen that platform, we continue building more survivors coming in, and you know, they'll be able to access justice through legal practitioners.
Thank you so much, Ngozi. You spoke so beautifully about that. That
Thank
was
you.
very
Welcome.
insightful. I guess one thing I wanted to highlight from what you said was the peer support networks. Tell us more about that. What does that look like for you? Where do you see that happening?
Okay, it's an imagination in my head, and I have seen it. It somehow it's working out, because last year I sat back and I thought about all the people, all the inmates during my detention, all those inmates I got to know while I was there. I created a WhatsApp platform and I added some of them. So as we keep talking, you keep sharing our experiences, we keep advising each other, and then when PRAWA, that's the Prison Rehabilitation Welfare in Nigeria, an organization that is a member center to IRCT, when they wanted to have a program, and they called me and they said, how do we get across to other survivors that haven't gotten any livelihood support? I said, oh, there are so many of them. And I quietly went to my platform where I have these survivors, and I spoke to them. I said, look, you have to attend this program. It's coming up. That's a Human Rights Day. So what I am saying in effect is, if it goes beyond just a mere platform, online platform, we can strengthen it by helping these platforms, by helping survivors that have come together. A collective survivor voices can actually help this anti-torture movement to a greater height. That's the way I look at it. If there is a kind of support in the area of helping us to have meetings, helping us to have training, helping the survivors to know how to speak up about their situations, such a network could actually expand and help tremendously in the anti-torture movements, I tell you.
Thank you so much. I don't know if anyone else on the panel wanted to come in on that question. Otherwise, we have one more question to go to the chat for, which is a question about the context of Bangladesh. So in Bangladesh, many student protesters and bystanders were killed through indiscriminate shooting by the police during the July 2024 uprising, leading to the ousting of the previous regime. There's evidence that many of these shootings, but not all, were conducted by the government, I think is what it's saying. There are claims that the perpetrators are not law enforcement per se, but are sort of like affiliated with the government or paramilitary causing these killings. Is there a specific investigation process or legal framework for instances where these killings have occurred, and there's a question of the linkage between the government and the act of torture, because there's this intermediary group of paramilitary or government affiliated individuals doing the violence?
And I'll try to take this one. Unfortunately, I'm not aware of specific processes or international processes in place that can help that. It is unfortunately something that we see in many countries, and it is a question of gathering evidence, as much evidence that you can. If you're taking photographs or recording any information that you want to take to form a legal case, if you are taking that kind of information, think of the chain of custody of any information that you're documenting. There's various tools available that can maintain the integrity of a photograph, for instance. I think Eyewitness to Atrocities is one in particular that we recommend people use. So to help form the basis of any legal case, maintaining that chain of custody is really important. But it really is a case of investigating and documenting. I don't know if Renata, if you have any further advice.
Thank you, Helen and Andrew. I think yes, there are specific guidance. There is specific guidance on how investigations into torture allegations should be carried out. So, for example, even where there are no specific complaints, if there is a reason to believe that torture has taken place, whether in the context of protests or else, authorities should start an investigation promptly to preserve the evidence, like Helen was saying, and there are different ways of doing it. It's important that these investigations are independent. And so those that are allegedly involved in the torture, suppose the protest crackdown happened by police forces, it shouldn't be the same organ that responsible for that investigation. The investigation should be promptly, not only in terms of establishing it initially, but also so that it's carried out expeditiously, because you not only need to preserve the evidence, but you have an obligation towards survivors to actually implement all the necessary steps available steps to investigate that and understand in what exact context that happened. Where there is an element of discrimination, the discriminatory motive should be unmasked. And so the investigation needs to be efficient in all of these forms and thorough. The issue that many times we see, as Helen mentioned, is there's often a certain unwillingness from state authorities to investigate, and there have been examples of investigations at the international level being conducted in certain contexts, especially where there is widespread or systemic issues. And so the UN has established UN fact-finding missions, for example, which are a body of experts to investigate some allegations of torture where there is this context of widespread or systemic issues that I mentioned. But I think the recommendation at the national level as well from our side is often to make sure that these bodies are independent, exist, and do investigate these allegations thoroughly. And there must be some sort of transparency to allow civil society organizations to scrutinize that investigation, and for victims and survivors to actively participate and be informed of the investigative steps that were taken.
Thank you so much, Renata. I'd just like to move to a different question, which is actually coming from me based on the Mentimeter activity that we did about 20 minutes ago. So one of the questions we were looking at was, how could the international community support advocacy efforts? And one of the things that a lot of participants highlighted kind of had to do with documentation, so publication of data, empirical studies, thorough reporting. And I just wondered if the panel could contribute any good initiatives they know about, any best practices, any good ways that they've seen that done and happen. So how have you seen good documentation in the context of accountability for protest, torture during protests.
I'm happy to take this initially to give a few thoughts. I just wanted to recognise that it is actually really difficult to monitor and assess use of force at protests. But civil society can play a really important role and does play a really important role. And if you are kind of monitoring a protest, if you're there when a protest is actually happening, think of your own safety and the safety of the protesters as well. Like if you are taking video or photographs and if those people can be identified. I think a key to successful documentation is understanding the legal standards. So I talked about those earlier, but about understanding the necessity and proportionality and looking through the guidance that UATC has produced that have been put into the chat. The more you can understand about the specific equipment used can be really helpful. So, and how the police are using it. Looking for like context and patterns of how the equipment is used. Isolated incidents of use are really important, but if there's patterns, that can also be really important because it can show that there are policy failures or by the police or a deliberate strategy by the police of repression. With IRCT, Omega has worked on what's called the protest toolkit. I did just put it in the chat before. It's been developed by IRCT mainly for looking at injuries to be used by forensic doctors, but it is really useful. There's a visual kind of guidance on kind of monitoring protests and how to keep yourself safe, as well as kind of detailed documentation that either a person that's at a protest themselves can fill in, or it can be used to kind of ask questions of people that have been there. And that goes through what happened at the protest, what equipment they saw used, what injuries were inflicted. And I think it is a really useful resource to help gather information.
Can I add something? I think what Helen was talking about the equipment and knowledge about all the law enforcement officer is very helpful. However, it has to be also empowering the local group to do documentation because they are the one who close, they are the eyewitnesses. But the problem in our culture, in our country, is that the real eyewitness are not documenting. So how can we help the local to document what they see, what they saw, and what they capture by mobile phone, and a lot of things were talking in the local language. So international report and our quality report has been later produced, but I think the report at the day or 2 days after, 1 week after from the local, it helped a lot for litigation, even 20 years back, 20 years later, or even something much longer. Another one is to have a very clear monitoring team, like the Child in Mob in Thailand, Amnesty International Thailand has been training a lot of monitoring team, wearing the jacket to show that we are monitoring violence against children in the protest. And it is very helpful to be visible that there are someone monitoring, that maybe we have a monitoring team monitoring the weapons, monitoring the tear gas, especially. So they know that people are expert is watching you doing your good job. Thank you.
Thank you, Noi, and thank you, Andrew, for leading us through the Q&A. We are coming to the end of this webinar, so I'd just like to thank you, Ngozi, Helen Noi, for such a rich discussion, and to our audience for the engagement. I think I speak for all of us when I say that the discussion today and all the insights shared will definitely support our work as practitioners seeking accountability for torture in the context of protests. And I hope that everyone found it interesting. Please stay tuned for any redresses or EUATC upcoming webinars and events, and do have a look at our resources on the website. Before you disconnect, we have launched a poll that will shortly appear, or it's actually already on your screen. So we would appreciate if you could please spend just a few seconds answering these questions before you leave the webinar. I will also post my email in the chat if you'd like to get in touch with us at Redress for more information on these topics, and we can also direct you to some of the resources that we mentioned in today's session. With that, thank you so much, everyone. Do answer this poll, please, and thanks again for joining us today.
Bye-bye. Thank you. Thank you, the organizer.
Thank you, Renata. Bye-bye.
Yes, thank you very much for this excellent
Helen,
discussion.
bye-bye.
Bye-bye.
Thank you, everyone. Thank you so
Thank
much.
you.
Keep in touch.
Okay. Let me look at it. Sorry. My oh, those panelists cannot vote. Just seeing this, trying to vote.